The committee will come to order. The second hearing on the Social Security Administration oversight examining the integrity of the disability determination appeals process, Part 2, will come to order. The Oversight Committee mission statement is that we exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It's our job to work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. The Social Security Disability Insurance Program and Supplemental Security Insurance Program have both seen explosive growth over the past decade. Through these programs, nearly 20 million people receive approximately $200 billion in annual cash payments. Yesterday, we heard testimony from 4 administrative law judges, normally called ALJs, who clearly rubber-stamped the cases brought before them. Rubber stamping not because they agreed with the lower determinations to reject these claims, but rubber stamping the lawyers who said, my client is disabled, even though competent administrators beneath had not once but twice, in many cases, said no. We heard from ALJs who created their own theories of disability, who awarded benefits to thousands of decisions without even holding hearings or considering the evidence, who failed to utilize medical or vocational experts during their hearings, who do not understand agency policy and repeatedly misapplied the rules of the Social Security Administration. And we heard about ALJs who fell asleep during hearings, who made inappropriate comments and gestures directed at female employees. Every case that comes before ALJs has already been denied at least once, and sometimes twice. Yet ALJs overturned a shocking number of these denials. Over the last decade, 191 ALJs reversed at 85% or higher these decisions. These 191 ALJs awarded lifetime benefits in excess of $150 billion tax dollars. Well, the ALJs that we featured yesterday do not represent the majority of judges, not by far. They do represent a sizable number of ALJs, and even one incompetent ALJ can waste billions of taxpayer dollars over the course of his or her tenure by inappropriately placing individuals on disability for life. Many of the ALJs who have demonstrated gross incompetence and profound misjudgment should be fired, yet action is rarely taken either by the Social Security Administration or Justice Department to stop misconduct or even illegal activity. Today's hearing will address the Social Security Administration role in this mess. For years, the agency's barometer for ALJ performance was a quantity of cases at that ALJs decided each year. Prior to 2011, the agency never investigated whether judges were engaging in proper decision-making. At multiple hearings now, including yesterday, ALJs told us and the committee that they felt pressured to meet a quota of decisions each year. Judges testified they received training from the agency to speed up their decision-making, including instructions to set an egg timer limiting reviews to no more than 20 minutes per case. Simply put, in the past, the agency's emphasis on high-volume decision-making directly contributed to ALJs likely awarding benefits to hundreds of thousands of people who simply were not disabled. Among its many responsibilities, the agency needs to deal with the ALJs who have lost or should have lost the public trust. I think it is obvious that all 4 of the ALJs that appeared before us yesterday should no longer be trusted to spend your money in the Disability Trust Fund. Today I want to know whether Ms. Colvin is going to take an aggressive approach in removing incompetent ALJs. Thus far, she has refused to heed my recommendation to take stronger action with ALJs Bridges, Taylor, even though both received multiple reviews showing gross incompetence and negligence. In 2012, the agency did make a necessary reform, and it did finally begin an assessment comparing all ALJs' volume of decisions and the quality of those decisions. The results of the study are clear. The results of the study are clear. From the study, there is a, quote, strong relationship between production levels and decision quality on allowances as ALJ productions increased. The general trend for decision quality is to go down. Now, to say that less mangled, quantity reduces quality, while having a reasonable quantity level allows for at least those ALJs who want to do a better job to do that better job. I appreciate the Commissioner being here today and appearing before the committee. Key questions before us are, what do we do about the people who were wrongly awarded benefits by ALJs, and how do we fix a system going forward? I trust the Commissioner is every day thinking about this and is prepared to give us her thoughts today and to answer our questions. I want to close by reminding all of us on both sides of the dais, this was not a problem of this administration. This was a problem that took a decade to grow. ALJs are not political appointees per se, but they are people who spend American taxpayer dollars at a higher rate than virtually everyone else in government. So as we work to fix a problem not created by one administration, I want us all to show deference to the fact that the problem is here before us. The problem took a decade to grow, and I look forward to working together to fix it. And I now recognize the ranking member.
I want to thank the Chairman.
Here, just, one of you use that, one of you use.
Hello?
Yeah, it wasn't me.
Is it working?
It's
working.
Now it's working.
This will be on the... My mic is working. Let me thank the Commissioner for being here. And Commissioner Colvin, we know you have a very difficult job. You're the steward of the Disability Insurance Program, which is a critical lifeline for people who become disabled and can no longer work. And I don't want us to lose focus of that. American workers contribute to this program out of their paychecks, hardworking Americans. They need and deserve to have a disability insurance program that gives them fair and timely hearings based on medical evidence if they become disabled and unable to work. I know you are working hard to get it right. The majority of Social Security Administration's 60,000 employees, including 1,500 administrative law judges, are doing the same. Many of them are my constituents. The majority of the Social Security Administration's 60,000 employees, including 1,500 administrative law judges, are doing the same. Many of them are my constituents. And by the way, the people who are serviced by Social Security are all of our constituents. And I don't ever want us to lose sight of that. They tell me themselves how hard they are working to provide the services that Americans count on. They also tell me that there have been instances now where one person is now doing a job that 3 people used to do. And the fact is, your efforts are working. Over the last decade, the Social Security Administration has significantly improved its efforts to collect and analyze data about judges' decisions. It has expanded training, improved performance, sharpened disciplinary procedures, and enhanced efforts to combat fraud. And the Chairman is right. If there are things that you think we need to do to help you address this issue, you need to let us know, because it's one thing for us to be up here criticizing the administration when we don't give you the resources you need and the backing that you need to accomplish what you have to accomplish. Yesterday, we heard from a handful of administrative law judges who fail to meet agency standards for conduct and professional judgment. No doubt about it. These judges are outliers who do not reflect good work of the majority of administrative law judges. We had 4 here yesterday. I understand there's about 1,500 in the nation. The evidence shows that the agency is committed to protecting the qualified decisional independence of the judge corps. And that is very, very significant. These judges act independent, and we heard them yesterday talk about how much they guard their independence. So you're really walking a real thin line here. On the one hand, you got to make sure they have independence, but like Chief Judge Bryce said in a transcribed interview, you also at the same time have to make sure that you can't tell them they've got to have a certain percentage going in favor and a certain percentage going the other way. And so it's kind of difficult to do. That commitment is fundamental to ensuring the integrity of the program and the rights of American citizens. We're talking about due process and equal protection under the law. But the evidence also shows that you are dealing with judges who go beyond judicial independence and ignore the policies established by the agencies. There's absolutely something wrong with that. In fact, you are now pursuing the removal of judges with the Merit Systems Protection Board when such actions were unheard of a decade ago. It is in all of our interests to get this right. We have a responsibility not just to highlight problems, but to correct them when they are identified. And that is why the spotlight should also shine on this body, us. Our investigation shows that Congress has failed to adequately fund program integrity efforts that would curb abuses. Congress has failed to provide the resources needed by the Inspector General, and we all have a lot of respect for our Inspector Generals, to combat fraud. And Congress has failed to provide the resources needed to provide timely access to disability hearings. Mr. Chairman, I would like to enter into the record an article from the Baltimore Sun reporting that residents in my district are waiting for 17 months for hearings.
Without objection, so ordered.
We heard testimony during our investigation that some people waited so long for their hearings that they died waiting. That is an outrage, and we're better than that. And that is one grave cause of austerity. Mr. Chairman, it's time to put our money where our mouth is. Is the Congress going to invest in the integrity of the disability insurance program? Is Congress going to adequately fund anti-fraud units in all 50 states? Is Congress going to appropriate sufficient resources to eliminate these backlogs? In my opinion, that is what we have to do, and that is what we must do. And I look forward to your testimony, and with that, I yield back.
Thank you. We now go to the gentlelady from California for a brief opening statement.
Mr. Chairman, thank you. And I would like to wholeheartedly endorse every word of my ranking member's statement. I think he put it extremely well. I want to thank the Chairman for holding this hearing today. It is the 5th oversight hearing that we've had on Social Security disability. The previous 3 were held in our Subcommittee on Energy Policy, Healthcare Entitlements. And again, I'd like to take note of the leadership of my colleague, Mr. Langford, and his leadership on that committee. During the course of the committee's oversight of Social Security, we have learned that there is room to do disability insurance better. We need to have more program integrity, more prevention of improper payments, and more commitment to improving quality. While the agency has taken steps towards reform, it has become clear that some of the concerns can only be addressed by Congress, with additional resources for quality assurance and program integrity efforts. Yesterday's hearing focused on 4 outlier judges that had unusually high allowance rates. In many respects, it was a dismal hearing. It was embarrassing, I think, for many of us to listen to. They processed an extraordinary number of cases, some without even ever seeing the claimant. In fact, in one case, I think it was Judge Taylor, of the 8,000 cases that he had, 6,000 of them were done on the record without ever seeing the claimant. And in some cases, substituted their own personal beliefs for expert medical advice. I do not believe that the judges invited to testify yesterday were representative of the Judge Corps. Most of the ALJs are conscientious public servants and had an allowance rate of 57% last year. Today, I look forward to the testimony from Social Security officials on the efforts to enhance its ability to oversee ALJs to ensure consistent and quality decisions. I hope they will address the concerns raised yesterday and describe the tools Social Security has put in place to train, discipline, and when appropriate, remove ALJs that violate agency policies. And having said that, I think it's very, very difficult to remove someone. And we need to have a very candid conversation on what needs to be fixed in order to appropriately remove individuals who are just frankly not doing the job. In April of this year, Chairman Lankford and I sent a bipartisan letter to Social Security that outlined several reforms and recommendations to improve the disability adjudication and review process to restore confidence in Federal disability programs. Earlier this week, I sent a letter to the U.S. Attorney from the Eastern District of Kentucky requesting an independent review for prosecution of the evidence Social Security had gathered with regard to the administrative law judge and a claimant's representative who allegedly colluded with fraudulent medical evidence to obtain disability benefit awards for thousands of individuals. The fact that Eric Kahn is still in a situation where he can represent claimants before Social Security in Huntington and in Charleston and anywhere else, I guess, in the country, because he's now opened offices in California, is a disgrace. It's an absolute disgrace. The American people expect and deserve action. I'm concerned that justice has been long delayed in this case. Administrative actions against the judge and the lawyer have been put on hold pending a possible criminal prosecution. While the Inspector General has conducted over 130 interviews, examined bank and phone records, reviewed decisions, and collected thousands of documents to build a case, we have heard nothing out of the U.S. Attorney in West Virginia. It's long past time to prosecute this case, and frankly, it's long past time for the administration within Social Security to take action against these people. One of them has retired. One of them is still processing claims. Social Security disability benefits are an important lifeline for millions of American taxpayers with disability. It is critical that this lifeline is preserved. Our investigation has focused on identifying improvements to ensure that only those who meet the eligibility guidelines receive benefits so that the truly disabled can access this important lifeline and the American public can have confidence in the disability determinations process. Our investigation has also shown that Congress has not provided the funding the agency needs to fulfill its mandate to effectively monitor program integrity and save taxpayer dollars. We know continuing disability reviews, CDRs as we refer to them, yield a return of $9 for every dollar spent. Common sense suggests to all of us that some people who are disabled get better, and there should be an active use of CDRs to make sure that those who do get better are not continued on the rolls. Social Security and the OIG have also established the Cooperative Disability Investigations Program to coordinate and collaborate on efforts to prevent, detect, and investigate fraud in Federal disability programs. Those efforts pay for themselves many times over. Yet for some reason, we here in Congress have refused to fully fund the Inspector General and the agency to carry out its program integrity. If we want accountability, I am going to use the same words that the ranking member did, then let's put our money where our mouths are and fully fund CDRs. I look forward to hearing the testimony on improving disability appeals process and how Congress can support and enhance these efforts. Thank you.
Thank the gentlelady. Mr. Langford. Openings. Okay. And there are no further opening statements. Then first we'll go to recognizing our witness. Members may have 7 days to submit opening statements for the record without objection. So ordered. Our witness, sole witness today is the Honorable Carolyn Colvin, and she is the acting acting Commissioner for Social Security Administration. Pursuant to the rules and procedures of our committee, Ms. Colvin, this is an investigative panel of Congress, and we swear in all of our witnesses. So if you'll stand. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give before this committee of Congress is the whole truth and nothing but the truth?
I do.
The witness has answered in the affirmative, and I'd like to welcome you. Since we only have one witness, we won't hold exactly to the 5 minutes, but if you could try to summarize your opening statement and comments. And if you have additional information that you'd like to be made part of the record, you can request so through the chair. With that, you are welcome and recognized.
Good morning. Can you hear me? Chairman Issa, Ranking Member Cummings, members of the committee, thank you for inviting me to discuss the role of administrative law judges, or ALJs, in our disability appeals process. My name is Carolyn Colvin, and I'm the Acting Commissioner of the Social Security Administration. We have nearly 75 years of experience in administering the hearings process. Since 1939, the law has required us to hold hearings to determine the rights of individuals to Social Security benefits. We currently employ just over 1,400 full and part-time ALJs who decide hundreds of thousands of disability claims each year. The vast majority of all ALJs are conscientious, hardworking, and take their responsibilities seriously. Getting the right decision to every person who applies for disability benefits is important to the agency, the claimants, Congress, and the taxpayer. Those who have earned Social Security coverage deserve a decision that is accurate, timely, and policy compliant, whether the decision is an allowance or a denial. Toward this end, we have taken steps to comprehensively improve our national hearings and appeals process. As our budget allowed, we made a large investment in modernizing the hearings process and utilized improvements in technology. We have developed new methods of capturing structured data, which provides insight into policy compliance in hearing decisions. We have developed new tools that use this structured data to provide ALJs real-time access to their appeals counsel remand data and provide them individual feedback. We collect and then analyze data to identify recurring issues in decision-making by performing pre-effectuation reviews on a random sample of allowances and post-effectuation focused reviews that look at specific issues. By performing these reviews as allowed by our regulations, we provide ALJs timely guidance on recurring issues in decision-making, consider improvements in policies and procedures, and identify training opportunities for ALJs and other agency employees. Our ability to perform these reviews, though, depends on the funding we receive from Congress. Our continued focus on quality review initiatives allow us to improve the policy compliance of ALJ decisions to ensure that individuals who qualify for benefits receive them, and that those who do not qualify do not receive benefits. Most ALJs who receive feedback welcome the opportunity to improve their skills. Let me emphasize that we do not have any set allowance for denial rate. We do not, because our focus is always on producing quality, policy compliant decisions. For our hearing process to operate fairly, efficiently, and effectively, Our ALJs must treat members of the public and staff with dignity and respect, adhere to ethical standards and agency policy, be proficient at working electronically, and be able to handle a high-volume workload while maintaining quality and issuing policy-compliant decisions. The vast majority of our ALJs take seriously their duty to the American public and perform their duties accordingly, and I commend and thank them for their service. We manage our ALJ Corps in accordance with the Administrative Procedures Act, and we ensure the qualified decisional independence of our ALJs. The APA additionally provides that ALJs are exempt from performance appraisals and cannot receive awards based on performance. In compliance with the APA, we can and have taken steps to ensure that ALJs who refuse to do their jobs properly or who otherwise betrayed the public trust would be held accountable for their actions. Despite the good work of the vast majority of our ALJ Corps, it has been necessary to seek removal or suspension of some ALJs. To do this, we have to complete a lengthy administrative process that lasts years and can consume significant amounts of taxpayer dollars. Unlike disciplinary action for other civil servants, the law requires that ALJs receive their full salary and benefits until the case is finally decided by the full Merit Systems Protection Board, even when the ALJ's conduct makes it impossible for the agency to allow the ALJ to continue deciding and hearing cases or to interact with the public. We welcome your support in advancing our goal of providing every person who comes before our agency a timely, quality, and policy-compliant decision. Again, thank you for the opportunity to appear before you today, and I will answer any questions you have.
Thank you, Ms. Colvin, and we will first recognize for the purpose of questioning Mr. Langford.
Ms. Colvin, thanks for being here as well. Ranking Member Spear and I sent a letter to your office about a month ago or 2 months ago. We received, they had 11 specific recommendations or ideas about how to reform this. It's been part of this ongoing conversation, now our 5th hearing dealing with this issue. We continue to collect what are the ideas that are actually solve this problem. We're all very aware of the problem. How do we actually solve this? We list out 11 specific ideas. The letter that we received back to your office said this: some recommendations could benefit from further discussion of our current business processes, the relative advantages and disadvantages of pursuing the suggested changes, and significant legal considerations. We'd be happy to discuss these recommendations with your staff. What we want to know is, how do we actually start applying some of these? Of the 11 recommendations, I would ask again, of the 11 recommendations that we put forward, I would like to receive a response back to Mrs. Spear and I that says, of the 11, here are those that we're already implementing, here are those that we don't think is a good idea, rather than, hey, we'll talk about this at some point, you want to be able to get together. I think it's a reasonable request.
I certainly can respond to you about each of the individual recommendations that you set forth. However, I did believe that some further conversation would help to clarify some of the recommendations if you feel that you would rather not do that.
No, we're fine with that. We've had offline conversations. We don't have to be in front of the cameras to be able to have this kind of conversation. What we want to see is, how do we actually move these into solutions? What we've tried to clear up from the beginning on these hearings is, what are statutory issues you need help with in the law? Where do we have a problem in the law that we need to fix? Where do you already have statutory authority that we just need to help provide a push and accountability to say, how do we get this done? So we have no issue to be able to talk through what's our part, what's your part, but we want to see us make progress on this.
We'd be very happy to do that, Mr. Langford. We appreciate the assistance of this committee, and we look forward to working with you. Okay.
We'll look forward to getting a chance to be able to get together on that.
All right.
There are several issues that have come up during these conversations. Yesterday's hearing, as Mrs. Spear mentioned before, was depressing in many ways. It's frustrating both to be able to see individuals that would claim judicial independence, that they basically are going to create their own way. For an ALJ to not have in the medical record in front of them that there's a back problem, but they ask someone in front of them, do you have a limp? And they said yes, and they give them disability. Though there's no medical evidence of that, do you have a limp should not qualify for $300,000 of lifetime benefits to the taxpayer. And do you have a limp does not also say to someone, you're not eligible to work in any location in our economy, which is clearly within the vocational grid requirements. When those issues come up and come up in a focused review, our frustration is they are rare, and thankfully that they're rare. But we have 191 ALJs that have this very high overturn rate. And what we're trying to consider is, what do you need to help in the process to be able to help fix this so that you can bring both training that works, because what we heard a lot yesterday was, yes, we have training, but it's really training on writing better. It's not training on writing and on policy and on how to make decisions. All four of the judges agreed the training that they've received is on writing better opinions rather than actually making better decisions on it. So that's one aspect of it. The second one is, when you find someone that needs to be removed, what do you need from Congress to be able to clarify the law? As you mentioned in your opening statement, the law doesn't allow for removal or holding pay or such.
Let me respond first by saying that we expect all of our judges to issue quality, policy-compliant decisions.
Well, we do too.
We respect their qualified judicial independence, but we also know that they're employees of the agency and they are accountable to the agency and to the taxpayers. So when we identify that there is a problem through our focus reviews, we do in fact provide very timely, real-time feedback. We provide additional training for those individuals, and then if they still do not comply with policy, we move forward taking appropriate action.
When you have a focused review, is there any sense of setting this person aside to say they're not going to hear cases while there's undergoing a focused review that you saw problems with, do the training, or are they still taking cases at the same time?
We do not set them aside. We provide them with training and work with them to improve those decisions.
So they're still hearing cases, though they're still going through training to say, we saw problems in your focus review, but they're still adding more cases even during that time period.
We are not able to just remove a judge from hearing cases because they need additional training. Our responsibility is to provide that training first, provide them with an opportunity to improve, and then if they still are not policy compliant, we take appropriate action.
Is that appropriate action include them not hearing cases at that point?
It could be. It depends upon what the situation is.
See, here's the ongoing problem that we have. You have someone that your group has identified to say there are some problems here in the way they're deciding cases. They don't seem to be following the basic flow of those 5 elements that need to be there. If there's a problem that rises to the top on that, they don't need to continue to hear more cases through that time period. We need to not have them hear cases, make sure that they're trained and ready to go, and so that the next time they start hearing cases again, they're actually following proper procedure that's been outlined by the law and by regulations.
It is not that simple, Mr. Langford. There is a process that we must go through. We do that. We take the responsibility of providing correct decisions very seriously, and we take steps immediately to try to...
So how long is that process?
Well, if you talk about the Merit Systems Review process, where we make a referral because we believe that a judge has either improper conduct or is not policy compliant, our experience has been it could be 2-3 years. It costs us $1 million to remove just one judge. So the process is very lengthy and very
Okay, so we've got a 3-year process with someone that there's a very clear problem with.
It's not our process, Mr. Langford. We have to follow.
I understand. I'm just asking the question, how do we fix this? Because we got a 3-year process. Someone's continuing to hear cases, approximately $300,000 to the taxpayer of every single case that they hear if they choose to put them into the system. It continues to roll on the taxpayer, and we still continue to have a judge that says, do you have a limp? You qualify for Social Security disability. Now, I understand that's an extreme case, but if that rises up to that level, which you have a few judges that are at that level, how do we protect the taxpayer and the integrity of the system so that if someone is coming for the disability and an ALJ, they're consistent across judges? I know there's subjective decisions here, but if you come before one judge, it's a 15% approval rating. Come before another one, it's a 99% approval rating.
Well, I think that you need to understand that we cannot look at one statistic, whether it's an allowance rate or denial rate, to determine whether or not the decision was the right decision. There's much more.
Yes, ma'am, I do understand. I'm over time, Mr. Chairman. I apologize for that. But let me just say, if you're a small community bank, when the regulator comes in, he looks at every other community bank and how they do loans. And if you're an outlier, you get extra attention because that's the way they're overseen from the FDIC and the OCC. Any outlier number that sits out there, they're not trying to, you don't have a quote-unquote quota, but if your numbers are odd compared to everybody else around you, you're going to get extra inspections. All we're asking is, would that occur with Social Security in the disability process, that if you have an outlier, whether they're on the low side or the high side, someone's looking at that saying, why is this number so odd? You
are aware that we do focus reviews. We cannot single a judge out simply because of his allowance rate or his denial rate. But if we find that there are policy, problematic policy decisions, we can work with that individual for further training and ultimately action if necessary.
So is that the law, that you can't single them out because of high allowance rates?
That is the law.
Okay, then we need to fix that for you, because that's trapping. That's the kind of stuff we're talking about.
Well, I think
that we all see the problem. We need to know what is our responsibility and what is yours, and so we can fix that.
Mr. Langford, I think it's important, again, to just emphasize that allowance rate or denial rate does not necessarily indicate that the decision that was made is an incorrect decision. So there are other variables that we have to look at.
By the way, we should probably pass that on to the FDIC as well, because they do that same treatment for banks, and they have the exact same response. So with that, I yield back. I apologize.
I just want to clarify, we'll go to the ranking member, but you're saying that it is the clear foursquare of the law and you have no ability. You're not saying that it's your interpretation, et cetera. You're saying you have absolutely no authority under the law to do anything different, or these are rules and policies and interpretations of the Social Security Administration?
When you say to do anything different, law has been very clear that we have to respect the judicial independence, that we cannot look at a judge's allowance rate or denial rate as a factor in determining whether or not that judge is qualified to do the job that they're doing, that there are many other considerations. There's also a process involved if we determine that we are going to take action, and that has to be.
Now, I appreciate that, but the subcommittee chairman has done a great job of reviewing this, and the only thing he didn't hold you responsible for is if you can't consider the ALJ wrong and there's a 99% reversal, then are you looking at the people that were wrong 100% of the time in other words, if there's a 99% reversal and there's a 57% average, then somebody's screwing up 30% below, and you're not restricted from asking whether the previous rejectors, 1 or 2, were right or wrong, are you?
If we do a focus review and we identify policy problems, we are able to determine whether or not that case needs to be placed in our CDR or moved ahead in our CDR workload. When we have the resources to do all of our CDRs, those cases will automatically be reviewed. But since we don't, if we do a focus review and we see that there is a policy problem in that area, we can, and that individual may in fact have been determined to be disabled, when in fact he was not, it was an error, then we could in fact move that forward for a CDR.
Thank you. The ranking members.
I'm going to let me ask this. I tell you, Commissioner Colvin, you know, I don't want to forget. I'm going to ask you some questions about the judges, but there are people in my district who are denied the 2 times. They keep talking about the 2 times denial, and then they say they overturned. And in the process, they go broke. They have nothing to live on. And I'm concerned about these 4 outlier judges, but I'm also concerned about people like the man that had stage 4 prostate cancer that died before he could get disability. And I see it over and over again. So I'm going to ask you some questions about what happens in stage 1 and 2. In other words, you got 2 people apparently who make a judgment when the case first comes in. Is that right? The 2 stages, right?
Yes.
And I also know that a lot of people in minority communities don't have doctors. They don't have lawyers. So they come in, and as I understand, I mean, this is just based on talking to constituents. They come in, and so what happens then? They're presented. What do they present? They say, "I'm disabled." So we're getting the impression that these are golden decisions, these first 2 tiers, and I'm just wondering what happens there.
That's an erroneous assumption, and I'm glad you raised that. When the decisions are made at the DDS level, they have not seen the individual. When they get to the ALJ level, it's almost a new case. First of all, it's generally a year or longer before that ALJ hears that case. New evidence has developed. The person has the ability to testify about their condition, which does not happen at the first 2 stages. They have the ability to bring in an expert witness to also substantiate their finding. In addition, you have additional deterioration, if the person has been waiting more than a year and has a disability, their medical condition is progressing during that time. So many times by the time the case gets to the ALJ, there's new evidence, and the person's condition is such that it would now make them eligible for disability where a year or 2 years earlier it may not have. Remember that for a very long time we've had cases that are well over a year old by the time they get to the hearing level.
Yeah, and those are the people, again, who have nothing and who continue to suffer with nothing. I know people had to go and live with relatives trying to make it off of zero. And so let me ask you another thing. The Chairman talked about this issue of over the years, people asking, that is, people an authority at the Commission, telling judges to move the cases faster. I didn't hear this testimony, but I'm sure he did. Something about 20 minutes a case. I didn't hear that yesterday. I think I was here the whole hearing. But maybe I'm sure that's accurate. Tell me about that.
Well, I have no knowledge of that. That would not be sanctioned within this organization while I'm here. We stress the fact that we expect a quality decision, that it has to be policy compliant. Yes, we want a timely decision because, just as you mentioned, we've got thousands of people waiting for a benefit to which they that they've paid into a system and earned. But we don't want them to rush through making a decision and then make the wrong decision. We do a quality throughout our process. We do a number of reviews prior to pre-effectuation, prior to payment, which we had not done before. That has to be a sampling. And then, of course, we can do the focus reviews that we talk about. So we are always focused on quality. I'm not going to speak to what happened 5 or 10 years ago, but I will tell you that that's unlikely occurring in this organization at this time.
Now, several of the committee's hearings have discussed continuing disability reviews, called CDRs, which are periodic reevaluations to determine if beneficiaries are still disabled or have returned to work and are no longer eligible for benefits. These are mandated by law, is that correct?
That's correct.
We have learned that CDRs are very cost-effective, estimated to save the Federal Government on the average of $9 per CDR, yet there's a backlog of 1.3 million CDRs. What's that about?
It's about funding. Congress has been unwilling to fund the CDRs, even though it's been demonstrated to be cost-effective. When I was here on my first tour of duty in '94, Congress worked with us and gave us 7 years of funding that we knew would be sustained and adequate, and we were able to totally eliminate the backlog. So if we really want to ensure that people are not on the rolls who are not supposed to be on the rolls, we need to be able to do the CDRs, but we can only do the number that we're funded for. This year, we're funded to do 510,000, and we will do those. Next year, in the President's request, we're expecting to be able to do 880,000. But again, that doesn't count now for the ones that are coming due this year, so we will still have a backlog. It has been demonstrated that when Congress funds us, we deliver. We can tell you exactly what we can do for the dollars that you give us. But we have not been adequately funded for this program integrity work. The other concern I have is that even though we got an increase in our budget this year, the increase was primarily program integrity. There was no focus on the direct services and the people that are still waiting to get the benefits that they deserve. It was only a focus on getting people off the rolls who should no longer be there. We need to balance that. We need to get people off the rolls who are no longer disabled, but we also need to have resources that will allow us to expedite these applications that are pending where people are waiting to be served who have earned a benefit and will die before they get that benefit because we don't have the resources.
On this subject, yesterday, Senator Coburn, who I have a phenomenal amount of respect for, said a number of things about the CDR situation, and I agree with him. The committee invited him and the ranking member of the Committee on Homeland Security and Governmental Affairs to provide testimony on the findings from his investigation into Social Security Administration adjudication process and oversight of ALJ. Senator Coburn stated that he believed a lot of CDRs are just a postcard mailed to somebody that says, "Are you still disabled?" And Senator Coburn then suggested a reform, and I just want to know your reaction to this.
Again, I think his...
Oh, you familiar with what he said?
I'm very familiar. I don't agree with him.
Okay.
We are not able to do medical reviews for every single individual, and therefore we have used a process that determines which ones we can mail to, and they identify or answer 5 specific questions, and based on that, we're able to determine whether or not they need a full medical review. But we validate that every year. We take a statistically valid sample, about 60,000, and we do the full medical review. And in every instance so far over the years, it has proven that the model that we use is correct. We have to use our resources wisely. It takes us costs us 20 cents to do a mailer. I don't know what it costs to do a full medical review, but it's costly.
But let me just tell you what he said, because he said what needs to happen, and I think you need to consider this. I believe is that people who we know are going to be permanently disabled and know that the medical science and the medical record would show there's not going to be a way for them to get into the workplace, those should never have a continuing disability review. Hear me now. And I agree with them on this. What we should do is recategorize those who get disabilities. Ones, what should be a short term, ones that have a chance, and then ones that have no chance, and then concentrate, but it needs to be a CDR. So in other words,
I think our current model, though, is very similar to what Senator Coburn discussed, because we do diary them. Our regulations require that we do them every 3 years, but we look at the categories when we do our diary, those likely to improve, those not likely to improve, and so we certainly are focusing on those likely to improve, and the model is such that we're trying to look at those who are more likely to improve. And as I said, normally we would be doing a CDR every 3 years if we had the resources anyway. We simply have to try to do those that are more likely to fall into the category where they're no longer disabled, because we don't have resources to do every single one.
Madam Secretary, I've run out of time, almost at the same time the previous speaker had, but I just want to say this. We want to get this right.
We do too.
Yesterday I said something that my mother told us years ago. She only had a second-grade education. But she says you can have motion, commotion, and emotion, and no results. The people who suffer are the people who, the constituents I talked about a little bit earlier. And so we need to get this right. These judges, if they're not doing the right thing, we want to work with you to get it done. If they don't belong there, if they don't want to follow procedures, I talked to the chairman yesterday. I said, when these people come in, they apparently come in saying they're going to obey certain procedures. And if they're not going to do that, I think we've got to address that. And by the way, judges, with regard to Social Security, they're not the only bad judges. By the way, we see them in state courts and other places too. But again, we're talking about the outliers. But thank you, Mr. Chairman. I appreciate it.
Most welcome. I now ask unanimous consent the statement of Judge J.E. Sullivan, U.S. Administrative Law Judge, from June 27, 2013, be placed in the record. Without objection, so ordered. Administrator, this judge is the one who gave us the testimony under oath that in fact an egg timer was part of his training. I presume that you believe that what he said under oath is true.
I don't have any reason
I'm sorry, that what she said was
question
true.
it. I'm just saying that that's not something that we would sanction.
Well, you did sanction it. The judge was trained in that and testified under oath. So I hope you will take back the assumption that unless she lied, the testimony you should review and find out how it was sanctioned.
Did she indicate when that occurred?
You will have a copy of the testimony.
Mr. Chairman, in fairness, I think she has she's only, how long have you been there?
She's been there for decades.
14 months.
Ma'am, how long have you been part of the part of Social Security?
I have been the acting commissioner for 14 months.
How long have you been before that?
I was there under Mike Astry for 2 years, but remember, he was the commissioner, and he determined.
That is the entire time that you have been with the Social Security?
Oh, I was there with Social Security back in 94 to 2001.
Okay. So you have been there during decades, and there is a relatively small.
Not decades. I was there 6 years prior.
6 years,
yes.
2 years, and 14 months.
Yes.
Okay. So for these 20 years from 1994 that are shown here, from 1994, if you put it up on the board, from 1995, I'm sorry, or 96 fiscal year, where the administration or the Congress provided $4 billion in funding until, let's just say, 2007, when they or 2010, when they provided over $10 billion. You keep talking about resources. These are decisions Social Security made in disabilities. These CDRs, when Congress stopped giving you specific mandates and set aside money, but the total amount of money was still going up. The fact is, in 2000, and by the way, this was during the Bush administration, in 2002, with approximately $550 or $5.5 billion, if I'm reading the numbers right, there were 900,000 CDRs. As the amount rose in the coming years, this blue line there is in fact the money going up, and the red is the CDRs going down. That's a choice. That is a choice. We did not restrict your ability. We did not deny you the ability to do CDRs. So during a period of time in which you were there the first time, your CDRs were going up like crazy. You had earmarked money, an order to do it. The money kept going up. When the earmark disappeared, it went down, and only, and by the way, I want to note that this was during the Clinton administration that a great job was done. During the Bush administration, a crummy job appears to be done when it came to reviews. And during the Obama administration, it's been going back up. The point, though, is that the money is going up. The resources are going up at times when it's going up and when it's going down. That is a chart that shows no correlation between money and your decision to do CDRs. Wouldn't you agree?
No, I would not agree. First of all, I've not seen your data, and I'd like my actuary to
Not my data, it's yours.
Well, I'd like my actuary to look at it and see if his interpretation is the same. But secondly, our CDRs and the numbers that we are allowed to do are clearly indicated in our budget each year. So when you say we have the flexibility to do how many we want, that's not accurate. We are identified very specifically how many we are expected to do.
Okay, well, let's go through. Ma'am, this is not the Senate. You can't filibuster. The fact is that you're talking about how hard it is to fire a judge. But what you're missing is a judge that rubber stamps 100% of the time, when good faith belief is that anything above about 57% is probably above average, and above 85% should give you a caution. You can save money by putting them on administrative leave and paying them to do nothing versus the false positives they're giving. Having said that, I'm going to ask you just a couple of quick questions, because I, like the ranking member, see a problem and see somebody telling me that if they'll just give me more money, and I don't think you doubt that that blue line is more money that's coming in every year under Republicans and Democrats. Consistently, that line goes up. So the real question here is, why were you giving awards to some of those 4 people that were in front of us today, awards for volume, and in fact not checking in any way, shape, or form whether or not they were out of the norm in the amount of approvals they were giving for disability?
We do not give awards to judges. I think the
letters that effectively are awards.
That there are letters that go to offices but not to individual judges. Again, that's something that happened in the past. That is not something happening today. In fact, letters are going out to offices commending them for their quality decisions, not for the number of decisions that they make. So now, a lot has changed, with even Senator Coburn recognized that there have been many.
Exactly. Once Senator Coburn in 60 Minutes made it clear that you were providing benefits to people that did not deserve it in large amounts, including, in some cases, people who were colluding with the lawyers or bringing the cases. Miraculously, your ALJs are now reversing, aren't they? They are, in fact, lowering the amount of claims they give. Are they denying people benefits that are entitled to them, or are they, in fact, more accurate today than they were before light was shed on this problem?
I think it could be a combination of both. I'm not going to conjecture here.
No, ma'am, you are the Commissioner. You've been the Acting Commissioner for 14 months. You have an obligation to give me a decision. Are we, in fact, denying claims that should be granted in great numbers as a result of this reduction?
I do not believe that we are denying claims in great numbers.
Then, by definition, the reduction is a reduction to a truer number, and we were falsely giving people benefits that were not entitled to them. Wouldn't you agree?
I would not agree.
Ma'am, you know what's amazing? that you want to come in here with a problem that up and down the dais we all agree is a problem, that there are too many people who are getting claims too slowly. But one of the reasons that the people who deserve these things are getting them slowly is we're clogged with a lot of people who should not get them, who know that the lottery will give them to them in high numbers.
I do not agree with that statement or that assumption at all.
You know, it's amazing. You don't agree with it, but you're running an organization that's costing us billions of dollars in benefits given to individuals who do not deserve it. You tell me you can't fire the ALJs. You tell me you can't do it. You tell me the law won't change it.
I never told you we couldn't fire ALJs.
You said
in fact, you know that we've taken action against a number of judges. We've had over 15 judges.
We had 4 of them yesterday that said things like they could see pain.
You know that there are a lot of actions being taken right now. I'm not going to discuss actions here that will jeopardize a case or litigation that might be occurring, but you know that there are a lot of actions right now.
Okay, let me ask you just one last question.
Yes.
And I appreciate the indulgence of the ranking member. Do you believe that Congress needs to give greater authority, not greater money, greater authority to fire, to reform, to review, if you are in fact going to represent the American people's best interest of their tax dollars?
I'm not prepared to answer that question. I think that I'd have to look at what the Merit Systems Review Board challenges are. I think that perhaps there could be some improvements there.
No, I wasn't. Mine was a much broader question. It was actually a softball right over the plate. For example, do you believe that we should give you the ability to do de novo review of judges whose decisions are in fact above the norm?
I don't believe that an allowance rate or a denial rate is sufficient to make a decision in that respect.
So in other words, if somebody's giving 100% approval, you don't think it's reasonable to give you the authority to review the review?
We have the authority to do a review.
You didn't do it.
We cannot single out a judge, a specific
judge.
Well,
only one judge gets 100%. Why wouldn't you do it?
Ms. Issa, we are doing focus reviews on those cases where we've identified problems.
I asked you about judges. I asked you about authority, and you won't give me an answer. You cannot think of one piece of authority that Congress could give you, one change that Congress could give you that would empower you to protect the taxpayer better.
I think that we need to respect the fact that there has to be qualified judicial independence, but we also have to identify ways
Ma'am, I asked you a question, and I just want the answer to the question. You cannot here today, if I hear you correctly, identify one area of authority or flexibility, not money, authority or flexibility, that would enhance your ability to protect the American people's taxpayer dollars.
I'd be very happy to give you a thoughtful response at a later time on that.
Ma'am, I will look forward. I will keep the record open for days or weeks to get your thoughtful response on congressional action that would give you greater flexibility or authority that would help protect the American taxpayer.
I'd be very happy to look at that, Mr.
I thank the gentlelady. We next go to Mr. Cartwright.
Thank you, Mr. Chairman. And I thank you, Acting Commissioner Colvin. I'm over here.
Oh, I'm sorry. Thank you.
I'm in the low rent district over here, Commissioner. I thank you for coming today, and I certainly thank you for your service in this hugely important work done by the Social Security Administration. And I'm concerned. I'm concerned certainly about outliers and judges who act badly, and I share the ranking member's statement that there are bad judges everywhere in every court that we ought to worry about. But I'm mostly concerned this morning about making policy decisions based on statistics that may be skewed and perceptions that may be incorrectly made on anecdotes. I think it's a mistake to make policy decisions based on these things. Certainly, we heard from 4 judges who may very well fit in the category of bad ALJs. We heard Mr. Lankford, who unfortunately is not here right now, talk about 191 ALJs out of 1,400 who are way above average in allowing claims. And one thing I wanted to touch on there was, and you said this, that current law prohibits you from reviewing judges based on their allowance rates or their denial rates alone. That may make sense. But one thing I wonder is, what about the judges who are denying claims way too much? I mean, I hear this. I know lawyers that are advocates and non-lawyers who are advocates for Social Security disability claimants who say they're denying more than ever these days. People who with legitimate injuries, disabilities, are not getting their claims allowed. And so there's anecdotal evidence on both sides of the ledger here. And I wanted to ask you about that. Do you keep track? First of all, do you agree that there are 191 ALJs out of 1,400 that are granting too many, allowing too many claims?
I don't have the exact number of the outliers, but I will acknowledge that we have had outliers. But if you notice, we have had a tremendous decrease in the number of outlier judges over the last several years.
So let's touch on the outliers that are granting too few appeals, who are denying claims. First of all, I think it's something we could all agree on, that in a universe of 1,400 ALJs and all of the thousands and thousands of disability claims that come in, that there are some legitimate disability claims that get denied, and those appeals are denied. Would I be correct in that?
You are correct. And as I say, we really focus on the right decision, a quality decision. And I don't focus much on whether it's a denial or an allowance, but is it the right decision? And certainly if we have someone where we believe that the number of denials is too high, then that's going to be a situation that we're going to be as concerned about as if we thought that they were out of the norm for the number of allowances that were made. Because people have a right to know that they're going to get a decision that is a quality decision and that is policy compliant and also timely. All
right. So we know that there are going to be some judges out there that are just not being fair and are not just not allowing claims that should be allowed, where we have legitimate claims where people have no money coming in because they can't work, they are disabled, and still they lose their case. And my question is, you know, as much as we talk about trying to figure out ways to get rid of bad judges who grant too many claims, don't we also want to look at ways to get rid of judges who deny too many claims? Would that be a fair statement?
Sir, I think what you're saying is exactly what I said. We want to make sure we get it right, that we get the right decision. We have increased our data collection, our data analysis, so that we can look at decisions to see where there are problematic policy decisions, and we can provide timely feedback to the judges.
Commissioner Colvin, let me ask you this. You've been paying attention this week.
Yeah.
How about those bad judges that have been denying too many claims? Were any of them invited to testify in front of Congress this week?
The bad judges
who were denying people legitimate claims?
An interesting question, sir. No, they were not.
They were not invited.
They were not invited.
Yield back, Mr. Chairman.
If the gentleman would take note, there was no minority witness. I certainly hope you considered inviting the administrative law judge, the one who was below 15% allowance. I guess not. With that, we go to the gentleman from Florida, Mr. Micah.
Thank you, Mr. Chairman. Ms. Colvin.
Hi, Mr. Micah.
So you have 1,400 of these administrative law judges, and you have 191, I guess, that fell into one of these categories as pretty high overturn ratings. And then you've got some that the other side has spoken to, I guess, or a few that have gone the other way. How many of these judges have been put on administrative leave since you've been there?
I don't have that exact number.
2, 5, 10, 20?
Are you saying in the last year?
Just the total, yeah, 13 months you've been there.
I'll get that to you shortly. I'll ask my staff.
Can somebody from the back provide that information?
Yes, I'll be able to give that to you before we leave here today.
Okay.
But I will say that since I've been the acting commissioner, we have a 25% decrease. We had outliers that were 25%. We're down now to less than 3%.
Okay. I want to know how many have been
activities we put in place.
put on administrative leave in the 13 months. The 13 months you've been acting kind of disturbs me because it's a pretty important position. You have pretty important responsibility. It's one of the biggest agencies in government, and certainly with the discretion in cases like this to grant disability claims. What's the problem with your getting? Are you before the Senate? Are you approved by the Senate?
No, sir.
Have you been submitted by the President to the Senate?
No.
So you're just sort of acting in limbo?
I'm running the agency, sir.
That concerns me because I've been in Congress a while. It's difficult enough when you have somebody who's confirmed, let alone someone who's in an acting position to get things done. And that's to your detriment to administer one of the most important agencies in government. These administrative law judges are appointed by whom?
They are selected through the civil service process. So the Deputy Commissioner, Glenn Sklar, who is over the ALJ operation, would be the selecting officer.
Does OMB participate?
No.
They do not?
No.
And then they're given lifetime tenure?
Yes. That's not an SSA decision.
Okay.
All of the ALJs.
Right. And that's set by law?
Yes.
I think that's something else we need to change.
Okay.
I chaired civil service for 4 years under this committee. I found
Mr. Michael, you had asked me about the number. We've had
put on administrative leave.
We've had 1 removal and 2 suspensions in 2014.
24 put on administrative leave?
No. In this year, 2014, we've had 1 removal and 2 suspensions. We've had a total of 15 removals since '07.
So it's very difficult to get rid of someone.
Yes, it's a very complex.
And as I started to say, I chaired civil service for 4 years. I found it's almost impossible to get rid of anyone. But they can be removed by you and put on administrative leave. Is that correct?
And we have many actions pending, but as I said, I don't.
How many actions pending do you have? Can you let the committee know on that?
Yes, be happy to do that.
You have a fraud division?
Yes, we have, well, not a fraud division. Our Office of Inspector General is responsible for fraud investigations. Our frontline employees make fraud referrals. Last year, we made over 22,000.
How many referrals?
Last year, we made over 22,000 disability fraud
And how many
referrals.
of those were pursued to a conviction or to denying disability?
I think there were only 500. That's one of our challenges.
So 500 out of 20,000 referrals?
Yes.
Doesn't sound like a very good batting average. Do you need more resources?
Now, the Office of the Inspector General is responsible for the fraud investigations, and of course, our resources are always helpful. This year, we increased.
How many people are in the Inspector General's office?
That's not under my authority, sir.
Can somebody answer that? Maybe we can get that in the record, too. We want to make certain that you have the resources to go after people.
Well, one of the things
20,000 and 500 successes doesn't sound like a good batting average to me.
Well, one of the things I'd like to see increase would be the number of continuing disability investigation units that we have. This was
how many do you have now?
We have 25. I'm increasing the number this year to 32, but again, it's based on funding. I'd like to have one.
After this hearing, do you think you can show leadership in an attempt to end the factory-like appeals process that's been demonstrated here the last couple of days?
I think we've already ended it, Mr. Michael. I think that that is something that was occurring, but I think that if you look at the fact that we've reduced the number of cases that a judge can hear during the year, we've capped that. We have the reviews in place. We have the tool of how am I doing.
How about suspending agency production goals until the agency?
We don't have agency production goals.
Well, it appears that, again, that system, even though you may not have a formal system, is in place. Unfortunately,
well, we are a production agency, so yes, we look at our budget and we determine what we think we can do based on the budget.
Well, you have target goals.
We have target goals in every aspect of what we do. Yes.
Well, finally, who made the decision to allow? Yesterday, we had some of the judges. You don't have to be on the planet too long to know that what's his name, Judge Cashver, shouldn't really be practicing. But you did a focus review in 2011. He was put on administrative leave and then put back on the job. Is that correct? Are you familiar with that?
I don't know the details.
I'd like to know who
case.
Can you get us for the record, who, again, overrode the decision on the administrative leave? Then he came back. Now he's on administrative leave because somebody needs to be held accountable for allowing someone like that to continue to serve in an important position like administrative law judge. Thank you. Yield back.
Thank you. The gentlelady from Illinois is recognized.
Thank you, Mr. Chair. I'm here. The Social Security Disability Program has long been a safety net for Americans whose disability prevents them from maintaining their employment. The program is an earned benefit in that workers must meet eligibility requirements for both insured status and for impairment. Would you explain what is required to attain insured status?
You said what is required?
Yes.
Sufficient earnings, sufficient quarters to be able to apply, to be eligible for the benefit. And so generally if the person has, I think, what is the number? Is it 10? Depending on age. 10 years of work. Yeah, 10 years of work, depending upon age, then they would be eligible for disability.
Okay.
Now, of course, you know, SSI is a means.
Ma'am, for them to record it, would you please speak into the mic if you could?
It would be, as I said, 10 years of work experience, and then SSI is a means-tested program, so they also would have to meet the income requirements.
If the applicant meets this standard, he or she must also provide evidence that a severe impairment prevents him from performing substantial work. Can you elaborate on the criteria for meeting this standard?
The process is very complex. It means that the individual is severely disabled, unable to perform prior work or any work within the job market. And so there are different variables that would go into that. I'd be happy to have staff brief you on the details because I think you need a little bit more information than I could give you right here.
Okay. Our aim is to provide benefits to those in their period of need with the ultimate goal of returning Americans to employment when and if circumstances allow. How does the agency evaluate the readiness of one to return to work, and are there programs that encourage reentry into the workforce?
Yes, we do the CDRs every 3 years, which are mandated. At that time, we determine whether or not the person has improved to the point that they now are able to return to work. We also have had a number of demonstration programs to identify what types of interventions might be necessary to help people to get back to work. You may recall that we have the Ticket to Work, which helps individuals to find work and provide some of the support services that they need in order to get back into the job market. I will tell you, however, that by the time someone comes onto our rolls, the majority of them are severely disabled and they're not going to return to work, although we do have a small percentage that return to work.
Yesterday, our committee held a hearing with the 4 judges, as you know, who have approved thousands of benefits, thousands of benefits costing millions of dollars. And it makes me uncomfortable that we're not talking about people. Instead, the decision is all about allowances and denials like they are widgets. Are these widgets, or are these people with unique stories, facts, and circumstances that judges have to understand and apply to the law?
I will tell you that for me, every number is a real person, and that's the one thing I emphasize to staff. And so I'm as interested in a person who is denied, who should not have been, as I am of someone who was allowed who should not have been. So for me, it's quality, quality, quality. I'm always focused on, are we making the right decision? And I've said that we will not sacrifice quality for quantity. So you will see that in many instances, our numbers are going up, our waiting times are going up, because we are giving the attention to the case that I believe needs to be given.
How many more judges would you feel you need so that the waiting time is?
Well, I've just authorized ODAR to hire 200 new judges this year. I don't have a figure on how many I would need to do all of the backlog, but only a judge can hear a case. So if I don't have judges, I can't hear a case. I'd be happy to try to provide information relative to what the ultimate core would need to be, but we are trying to keep it around 1,500. Our attrition rate is high because we have senior staff.
Okay, thank you. I yield back. Yes, I would.
I wish the Chairman was still here. He had said something about while you were at Social Security, and you promoted a certain policy, and I don't think you had the chance to answer that.
Well, I think he was wrong. He was inaccurate. I've never promoted the policy that we would just ramp out cases. Even when I was here before, we were very focused on the quality. The agency has made tremendous progress with being able to hold judges accountable, because at one time they said we couldn't hold the judge accountable for even coming to work or for the number of cases that they were done or the quality. And so there's been tremendous progress made. But when I was here, I was primarily involved in operations, which is our field office operations from 98 to 2001. And since I've returned, we have been focusing on quality throughout the agency, particularly with the disability cases.
All right, thank you.
I'm going to recognize myself now for questions. Could you identify your staff that's here with you today?
Yes.
Could you raise your hands?
You want them to introduce themselves?
No, I just want to see who's all. I want to see them nice and high. Can I see them, please? Ms. Colvin, did you watch yesterday?
Yes, I did some of it, but your streaming was not good. So
Okay.
most of the times it was.
How about staff? Did you watch that? Were you disturbed?
Absolutely.
Oh, it was. I'm from Western Arizona, and the people back home were seriously disturbed.
So were we.
So when we were talking about quality, and you talked about outlines, do we have a problem? I need to hear you say that we have a problem.
We have had a problem. It's getting better. As I mentioned, we've had a 20% reduction in the number of outliers. We're now down to 3% of our judges who are outliers.
Okay, so I'm going to interrupt you. I need to see something more.
What do you want?
What kind of timetable are we dealing with? Are we talking to infinity and beyond, or do we have a 2-year problem looking at enough money to fulfill what we're looking at?
I'm sorry, your question is not clear.
Trust fund, when does it run out?
2016,
so Mayday,
will be depleted.
Mayday, right?
The reserves will be depleted. We will still have funds coming in that will allow us to provide 75% of the benefit.
But 75% doesn't cut it for folks like that actually need it. So to me, it seems like a CEO is going to be talking about metrics, about what are our timetables. I want to look at quality too. I'm a dentist impersonating a politician, so a lot of this means a lot to me in regards to that. You made, in talking about yesterday, we have to get back to building blocks before we can reconstruct stuff. And so when I used yesterday, I was mortified that I actually saw judges claiming that they were doing bench reviews. You said that it's almost like a new case study by the time they get there. So it would remand that there would be very few bench decisions. Would you agree with that?
And in fact, if you look at our data, you'll see that there are very few being done anymore. I can provide you with a chart.
I saw 4 right there that, boy, I tell you what, there needs to be a clean sweep right there. I saw 4 judges here and that know they didn't have a medical license. They weren't using expert testimony.
There should still be some situations where you have on the case reviews without a hearing or decisions without a hearing, on the record reviews, but I'm saying the number that occur has significantly decreased.
I'd like to see those numbers.
All right, we'd be happy to provide that.
I like validation.
We have it. We'll be happy to provide it.
I'd love to see that validation. What wouldn't, do you need more information from seeing those 4 judges yesterday to take action?
No, because most of what you presented yesterday were our documents that we provided to you. So what they provided was not a surprise.
So why aren't they all on suspension?
I don't know what their individual situations are, but as I've said to you, I'm not going to interfere with any case where there's criminal action or where there's an action that could then be affected because of my speaking out publicly. But we'd be very happy to come to you and talk to you privately or the committee about all the things that we're doing in this area, because I think—
No, I think America needs to hear it. Don't need to hear it from just behind closed doors. I think you need to hear it all the way across the board.
Dr. Gossa, there are privacy issues, and we also do not want to jeopardize criminal investigations by giving information out in public. These are not going to be cases that are not going to be litigated.
Well, I think a good step is to admonish them, but not allowing them to hear any cases. I mean, if you talked earlier about quality. I mean, right there is a good faith exercise in making sure that we have quality instead of quantity, wouldn't you say? Putting them on administrative leave, and do you not have that ability to do that?
I'd be happy to talk to you later about individual cases, but you know, even when we—
Let me ask you a question. Do you not have the authority to put those individuals that we saw yesterday on immediate administrative leave? Yes or no?
I have authority to put individuals on administrative leave, yes.
Have you put those 4 on administrative leave?
No, I have not.
Why not?
I think there has to be considerable thought, and there are actions pending. And
oh, my goodness gracious. You didn't see that yesterday with those 4 individuals? We had a guy that was interpreting his own interpretation of what disability was. We had a gentleman that over here has a conflict of interest. We had gentlemen that saying that they knew more about medical than a medical doctor. Come on now.
You don't want to hear my responses because you're not listening. Some of them are already, those individuals that spoke, action has already been taken.
Some of them?
One is
How
already—
come not all of them? I mean, I think across the dais we were all mortified by the 4 gentlemen that sat here yesterday.
We were too.
Then why aren't they all on administrative leave?
I've given you the answer I can give you, sir.
You said a few.
I've said
you have
that we—
You actually have the jurisdiction, you as the CEO for the administration of the Social Security Administration witnessed what we saw as despicable responses from 4 judges. And you have the ability, which is what you just told me, that you could put them on administrative leave, and yet all 4 of them are not on administrative leave?
My answer is the same. I'm not going to discuss personal actions here in this forum.
That's the problem that we got right now, is accountability and actually having a line item and a direction and a path of holding people accountable. That's what's wrong.
I'm happy to talk to you privately. I'm not going to have that discussion here.
You know, if you can't tell America, that's a disgrace, especially after what they saw from those 4 judges yesterday. No, I won't take the comment.
I'm not going to jeopardize actions because you feel that I've not handled things appropriately. I mean, that's your opinion.
I think America's opinion was yesterday, what they saw yesterday from 4 judges was disgraceful, absolutely disgraceful. There is no reason one of those gentlemen should be able to hear one case whatsoever. And that does not, putting them on administrative leave does not deter any judicial proceedings at all. That's the problem that we got here. We got less than 2 years. Less than 2 years. You had 5 minutes over time. So
that's because, wait a minute, hold on.
You had 5 minutes.
I had 5 minutes because the gentleman who spoke first, what was his name?
So everybody's taking their 5 minutes.
No, that's not true. That's not accurate.
I've been sitting down there watching it.
No, the first questioner on your side had 10 minutes.
The gentleman is out of order. I'm reclaiming my time. I would love to see, what you're looking at as far as an orchestrated plan to make sure that this is solvent, not only with the ALJs, but to also make sure that we're reviewing the people that are on the 1st and 2nd level aspects, because there's a coordinated aspect there. I got one last question for you. Is there any reason why somebody wouldn't have the ability to work? I mean, when you look at a claim for perpetuity, wouldn't there be there would be very few cases, would you not agree, that somebody could actually be a benefit to doing an alternative job?
I have no idea what your question is designed to get at.
Well, permanent disability. Isn't there an opportunity or a job that somebody with a disability can actually do?
I'm not a physician, but we apply the policy, and it states very clearly that if an individual is not able to perform prior work or any work in the job market, then they're disabled.
Partially or full?
Full.
Full. So it doesn't matter if we got a back injury and we're out chopping wood.
You have the law. You can take a look at it.
Well, the chairman actually asked, were there opportunities? I think Mr. Micah also said, are there opportunities that we can change in the law to make this more solvent and better for you to orchestrate a solvent plan? So with that, who's the next person? Ms. Spear.
Mr. Chairman, thank you. Mr. Chairman, let me just say for the record that it's very important for us to not jeopardize the disciplinary actions. He's not listening to me. The disciplinary actions that are ongoing within the Social Security Administration. And the Social Security Administration should not be in a situation where they're tipping their hand as to what strategy they are using relative to pursuing the actions against those judges. So I think that's very important for us not to thwart their efforts in getting a just decision in the end. And that may be why Ms. Colvin has not been willing to respond to your questions. But having said that, I think that there are lots of areas that need to be fixed. And I don't think this will be your first visit here, Ms. Colvin, or your last. I know it's maybe your first, but it won't be your last. Let me ask a couple of questions as it relates to Huntington. I had a whistleblower in my office yesterday who described continued retaliation at the Huntington, West Virginia office. So my question to you is, what is the status of the managers who retaliated against whistleblowers by hiring private investigators?
You are aware that Huntington is an open case, but we removed the ALJ, Andrus, I think his name was.
No, I know all about that, but there was also an investigator that was hired to watch one of your staff that was working one day at home and trying to bring some action against this particular individual because this individual had been a whistleblower.
May I get back to you?
You certainly can, but I would appreciate that.
Okay.
So in Huntington, you have a claims representative who is clearly implicated in his relationship with Judge Dougherty, and bank statements and documents are very persuasive. Now, the fact that the U.S. Attorney has not taken action yet does not preclude you from taking administrative action. Is that correct?
I'm not sure of that, Ms. Spear. I need to check that.
Well, I mean, that's pretty
normally when my general
fundamental.
Counsel gets involved and there's a criminal investigation, I sort of take a back seat until we determine exactly what's going to happen there so that we don't do anything that's going to interfere with that criminal investigation. So I wouldn't be prepared to tell you that now, but I'd be very happy to come back and talk to you and bring the general counsel.
All right. I think it's important where you have U.S. Attorney who appears not to be taking action. You have powers to take administrative action, and administrative action should be taken.
But we have not given up on expecting that we're going to get some criminal prosecutions there.
Well, I want you to go back with your staff and determine whether or not, while there is still something pending, whether or not you can take administrative action. Eric Kahn should not be allowed to continue to represent claimants. And as I understand now, he's opened an office in California as well. So
I hear you. I will take a look at that, and I will get back to you on that, Ms. Spears.
All right. The issue of a lifetime term is one that I really think needs to be addressed. We have a workers' compensation system in California. It has a very similar function to the Social Security disability process on a federal level. These terms are not for life. And I don't know the history for giving these judges terms for life, but I think we've got to look into it. And I, for one, believe that we should look at giving them set terms. And I think you're going to see greater accountability over a period of time. My time is almost up, but I'd like to just ask you one other question, if I could. Is there anything else that the agency can do about Eric Kahn, separate from the criminal prosecution?
I would have to get back to you on that. Because, as I said, I've been deferring any action that I would think necessary until such time as I know what's happening with the criminal action. I understand that we have begun to move forward with the administrative process.
All right. So you can act independently.
Yes.
But this has been going on for how many years?
Oh, a while. I don't have the exact number of years.
It's been at least 5 years, correct?
I understand it's been 3.
3 years.
Still 3 years too long.
And he's still representing claimants. All right, my time's expired.
Gentleman from Tennessee, Mr. Duncan, is recognized.
Thank you, Mr. Chairman. Madam Commissioner, on 60 Minutes last year, the Vice President of the Association of Administrative Law Judges said this, quote, if the American public knew what was going on in our system, half would be outraged and the other half would apply for benefits. What is your response to that?
Well, I don't know what they were referencing. We know that we have many well-deserved individuals who are on our rolls, that we take every effort to make sure that people who are not eligible do not get on the roll. So I'm not sure what they were referencing, and they've never shared their thinking with me.
Let me ask you this. What percentage, I know the rate of approvals has gone down in the last few years, but since more attention has been called to this, but what percentage of cases are being decided without a hearing? Do you have that?
Yes, I can give you that number, not the second, but I can give that to you because I have a chart here.
I mean, one of these judges yesterday had approved almost 7,000 without a hearing. I just wondered, and without asking any specific names, have you referred any judges or lawyers to the Justice Department for possible criminal prosecution?
Their personnel actions are being undertaken in some instances. And as I said, I think it might be desirable to try to give this committee or those who are interested a private discussion of all the things that we're doing so that you can see that we are trying to address this comprehensively.
Well, I know you're trying to do some things through in the Social Security Administration, but are you also working with the Justice Department on this?
Absolutely.
All right. And let me ask you this. You're reviewing and have reviewed the judges to determine the number of outliers. I remember several years ago seeing another report on 60 Minutes that told about a region or a section in Arkansas where children were being told that it was easy to get what they called crazy money from the Social Security Administration, and were being taught to fake mental illness and so forth. Are there any particular, are you also looking at particular offices or regions that are having higher approval rates than other regions? Do you look at that also?
Of course, as we look at judges, we would have to look at offices. So we know what, yes, we know where the high approval rates are occurring.
And are there any particular offices or regions that have extremely high approval ratings or disapproval ratings at this time?
I don't think that there's any office that's unique where it's much greater than elsewhere. As I mentioned before, the number of outlier judges is now down by 20% to 3% of the entire ALJ Corps. So we're still addressing that, still working on that.
Our committee brief says 19.4 million people are drawing benefits from your two major programs right now. Is that correct?
You mean the current number of recipients?
Right.
Well, we have 60 million beneficiaries. I don't know how many for disabled. Is it 13 million?
It says in our committee information, it says 19.4 million.
16 million.
And it says that 3.4 million were approved between 2005 and 2013.
I don't have that data with me. I can certainly take a look at that.
All right.
I don't have the data by year.
What is the what do you think, what is the main, is there anything that you feel needs to be done that you don't feel you have the authority to do at this point that Congress could help you with?
I'm taking a look at that now. Mr. Duncan, I have the letter that came from the committee with recommendations. I agreed to go back and look at that more thoroughly. I had wanted to have further discussion with staff about and get some clarification, but I said we would go ahead and just respond, and then if we need more clarification later, we'll do that. But we do want to work with the committee. We want to try to identify the kinds of things that we think might be helpful to us. The biggest challenge is the fact that with the qualified judicial independence, we have to be respectful of that. We cannot single judges out because of their allowance rate, and so we have to try to get to those from another angle. And then the ability to remove a judge is very difficult, very complex. We have to work with the Merit Systems Review Board. And so as we work with those things, if we think there's anything where Congress might be helpful, we'll come back and talk with you.
Well, one last comment I'll make is I was a judge for 7.5 years before I came to Congress, and the lifetime terms that Ms. Spire just mentioned, she didn't know what was behind that. Those were started many years ago when there were far fewer lawyers, and the judges were lower paid than they are now. And what you have now, you have really too many lawyers, and you have lawyers jumping at a chance to become administrative law judges or federal judges of any type, and you just really don't need these lifetime terms anymore. We should work on that and end the lifetime terms for all the judges that we possibly can. Thank you, Mr. Chairman.
I thank the gentleman. The gentleman from Michigan, Mr. Walberg, is recognized.
Thank you, Mr. Chairman. I'm pleased to yield my time to the Chairman.
Thank you very much. Ms. Colvin, do hearing officers have productivity goals?
I'm not aware that we have specific productivity goals. We have overall national goals.
What are they based on?
Our budget and the number of cases that we believe we can do with the budget that we're going to be allocated. And that's why we were able to hire or had funding for the 200 judges that we are going to be hiring this year.
Okay. Are you aware that the law requires ALJs to consider the claimant's entire case record prior to rendering a decision?
Absolutely.
Isn't that an access point for determining that they shouldn't, they can be put on administrative leave?
I don't believe so. I don't think that one thing would be the basis.
It's a requirement for law. Are you aware that until 2011, the requirement that ALJs consider the entire case record before reaching a decision was essentially meaningless before the agency did not even monitor, much less ensure that the decisions were policy compliant?
I can't speak to that. I'm not aware of that statement.
Frank Cruzado was Chief ALJ from 2006 to 2010. During this time period, hundreds of ALJs were approving nearly all claimants for benefits. When asked in his transcribed interview whether he was ever concerned that one of his judges was allowing too many people onto the program, he said no. Given the data that the committee has presented, do you find that stunning?
Do I find what stunning?
That almost everybody was placed on the rolls?
I don't know how to answer that. Do I find it stunning that almost everybody was placed on the rolls?
Yeah.
I don't know that I have any data to support that statement from, who was that, Judge Cruzado?
Do you know who Judge Cruzado was?
Of course I do. Yeah, I'd have to see the data.
Are you stunned that he wasn't aware of any judges that weren't giving overwhelming approval ratings?
I don't have one opinion one way or the other.
If we gave you that data, could we get an answer?
I'm sorry?
If we gave you that data, could we get an answer?
Get an answer to, am I stunned?
Mm-hmm. Okay. Mr. Cruzado testified that he was often very concerned about particular ALJs, or hearing offices, that were not processing cases quickly enough. Isn't that a lack of a balance or a major concern to you?
Well, I would think that if he were the chief judge and he was concerned, he should have taken some action.
Okay. Knowing what we know now, was it a mistake for the agency to have no quality metrics to evaluate ALJ decisions, as the agency encouraged ALJs to decide more cases?
Well, again, I'm not going to focus on the past, but I certainly believe that you have to have quality metrics. I'm very much into data and using that data for informed decisions, and that's why we focus so much on quality.
So quality metrics is a determining factor that we'd have to look at.
Well, quality is probably the sole factor that we should be looking at, determining whether or not, in fact, the decision is a quality decision, a legally defensible decision, a policy compliant decision. We certainly want timeliness in the processing of cases, but we don't want that timeliness to replace quality.
But if we don't look at the past, we're doomed to repeat it in the future, right?
Well, certainly, and that's why we've made lots of improvements, because we knew that the past was not where we wanted to be.
Since 2011, the agency had conducted 30 focus reviews of ALJs with allowance rates in excess of 75%. Every one of these reviews found significant problems with the way these ALJs consider evidence. Are you concerned by this?
I don't understand the focus of your question. All of the changes that we are making are designed to improve what we're doing. So your question about, am I concerned about what we did 5 or 10 years ago, I'm not sure I understand the relevancy of it.
Well, all the judges that you're reviewing have these types of problems. Would you agree?
Well, that's why we're doing focus reviews. That's why we're doing pre-effectuation reviews. I'm just not certain I understand what you're trying to get to.
Will you provide the committee with all the agency's actions taken as a result of the agency's focus reviews of ALJs?
Can we provide you with
all the agency's actions taken as a result of the agency's focused reviews of ALJs?
We have your question. We'll take a look at what it is that we have available.
Starting in 2007, when Frank Cursado was Chief ALJ, ALJs were instructed to issue between 500 and 700 decisions per year, correct?
That is my understanding.
Are you aware there are no underlying studies to justify the production targets?
That's what I'm told.
Are you also aware that neither current Chief ALJ Deborah Bice nor former Chief ALJ Frank Cursado have no idea how long it takes an ALJ to decide a case when they are properly reviewing the evidence?
I'm surprised to hear that, since they're both judges, that they would not know how long it takes.
I mean, you made the comment that each individual is an individual record, did you not?
Is it an individual record?
Yeah, it's exactly very personal. I mean, the chart could be huge, the chart could be small.
Well, I haven't addressed that. You never asked.
But it takes more time. I mean, the complexity of it's a mental health issue, whether it's a complex medical issue, wouldn't that kind of make it a personalized type of a format?
Well, I'm certainly not a judge, and I don't review cases, but I assume that there would be a variant, yes.
Do you think it's irresponsible to create a production goal without any analysis to back it up?
I don't have a production goal, so I can't respond to that.
Okay. I will acknowledge the gentleman from Virginia, Mr. Conley.
I thank the Chair. Welcome, Ms. Colvin. I think it's really important to note this is part 2 of this set of hearings, and clearly there's a narrative my friends on the other side of the aisle want to try to establish, but they're doing it by, I think, cherry-picking witnesses who distort the reality. So we get several administrative law judges with high allowance rates, in some cases exceeding 90%, even though the average national allowance rate is nowhere near that. It's in fact 57% as of last year, the lowest rate since Jimmy Carter was in the White House in 1979. So let's not distort facts here. Let's not try to manufacture a narrative that in fact is misleading, if not false. Commissioner Colvin, is it true that the Disability Insurance Trust Fund is forecast to become insolvent in 2016?
Not insolvent. In 2016, the reserves will be depleted. The income the resources that will be coming in will allow us to pay 75% of the benefit, yes.
Well, is that a serious thing? Could people be hurt?
People will be hurt. But Congress has acted before to address that problem. It's not the first time that we've come to the situation where the reserves were depleted.
Right. Now, again, the insidious nature of the undertone here in these 2 days of hearings is to allow the implication that I'm going to use the word insolvency, that the possibility of insolvency, impending insolvency, is because of mismanagement by the agency and administrative law judges running amok. Is it not true, however, that the trust fund was forecast to be possibly insolvent 20 years ago by the chief actuary of the Social Security Administration.
Absolutely, and the trustees. So we've known, and Congress has known for a very long time that we would have this problem in 2016, and the trustee reports reflect that.
In fact, we had Ms. LaConfora, the acting deputy commissioner of the Office of Retirement and Disability, before this committee in April, or the subcommittee, and she stated, the policy and the process and the management of the agency is not the cause of the reserve depletion. The cause of the reserve depletion is demographics, baby boomers aging, women entering the workforce. Care to comment, Ms. Colvin, about that?
Well, it's all been predicted. It's in our trustee reports. We've known that we would have the aging of the baby boomers and that they would be reaching the disability-prone years. We knew more women were entering the workforce and they would have earnings on their own record. We knew that the poverty rate is going down, so we have more children coming onto SSI rolls. I don't know why Congress expresses surprise. It's in writing in our trustee reports.
Yeah. And it's not, yeah. And, well, of course, if we really were determined to avoid a problem or do nothing about it creatively, we might try to pick on some tertiary issue that's really quite tangential to the heart and soul of what we're dealing with here, the reserve depletion.
I need to emphasize that our allowance rate is 44%. It's the lowest it's ever been in the last 40 years. In fact, I have many stakeholders who think it's too low. Of course, Congress thinks it's too high. But there's been a lot of effort to make sure that people who are on the rolls are people who deserve to be on the rolls. And that's why we have the CDRs, because the CDRs will identify people who have improved and will go off the rolls. So I don't see any valid data to tell me that we have huge numbers of people on the rolls who are not able or not disabled. And in fact, we have a lot of people waiting who should be on the rolls.
And even if there were too many people, I mean, that's hardly the solution to the issue of the depletion of the reserve, isn't that right?
Absolutely. Also, when Congress changed the retirement age, that meant that more people are going to be on disability until they reach the retirement age. So that also added to the number of people being.
So actually, Congress has something to do with the nature of the depletion.
Yes.
It isn't just for a handful of administrative law judges who may have excessive allowances. Is that correct?
I haven't seen the data, but I cannot believe that that number that's quoted about the number of dollars that would result from the allowance rates. I just have not seen it.
In the past, has Congress intervened when we've seen us get to a certain level in terms of the depletion?
Several times.
Several times. In fact, Congress has reallocated payroll taxes between Social Security programs at least 6 times in the past. Is that not correct?
Yes.
And a similar rebalancing would, in fact, extend the life of the trust fund, allowing for full payment of benefits through 2033. Is that not correct?
That's correct.
So maybe we could spend our time more creatively here in Congress talking about trying to find a solution to your problem rather than trying to finger blame in a tangential way that really begs the question. I yield back.
Would the gentleman like to input why the minority didn't bring their own witness to this hearing in the last 2 days? I mean, you could have given a fair and balanced.
You should. I don't speak for the minority, Mr. Chairman. I'm a member of this.
You're a very articulate member, and
well, I thank the Chair.
Had an opportunity to do so, and it's acknowledged no minority witness was chosen. I'd like to invite Ms. Luann Grisham for her time at the dais. Thank you.
Thank you, Mr. Chairman. I appreciate that, and appreciate that we're having what I'm considering sort of 2 bites at the apple to start to look at disability cases and the system that Social Security has in place to review those cases. And I ask, Mr. Chairman, I have a statement that I'd love to introduce into the record from an attorney in New Mexico who specializes in these cases and has been an effective advocate, and he uses in his statement about some of the staffing shortages information that comes right from the Social Security Office's website.
Without objection, that
All
will be
right.
placed on the record.
Thank you very much, Mr. Chairman. There are 164 ODAR offices around the country. How does the Social Security Administration determine the number of ALJs, decision writers, and other support staff in each office?
I don't think I can give you that formula.
Again, would you please speak into the mic?
I don't think I can give you that. I would have to get back to you. I needed to consult with the deputy for ODAR on that.
But no sense that it's based off the number of cases that each office receives?
Well, we anticipate that a judge can only carry a certain workload, and of course, we don't know how many individuals are going to come into an office who need our services, but that's why with the electronic services we can move.
And see, I would disagree. I think you do know. And in fact, the Albuquerque office currently has the 4th highest number of cases per administrative law judge in the country. And in fact, I've raised that point in writing and in communications with the Social Security Administration and have yet to get what I think is, a satisfactory response about, and we'll get there, about what we might do about that. And in fact, there are 822 cases per ALJ in the Albuquerque office. In the 16 other offices in the region, the average number of cases per an ALJ is only 500. Does that sound correct to you?
I don't know that figure, but one of the things that we do is we do move work around to help with understaffing. We are going to be hiring 200 new judges. We've not
But certainly none in my region, which has the highest consistent cases, and identifying staff in other places, which I appreciate given that we have 8,700 people in New Mexico who are currently waiting for a hearing on their case, which creates, as you noted earlier, and I really appreciate that very much, that you noted that there are significant other policy issues that are affected by not getting these cases adjudicated timely, and by the fact that Congress has made policy changes that create more of a demand for Social Security disability. But when you outsource these cases, it's like putting a Band-Aid on a broken leg. If this is where you know you've got significant issues, why aren't we making investments where we have the greatest backlogs?
Well, because we have them everywhere. We have the second longest waiting period in my own county, Baltimore, 17 months before a case is actually heard. So I'm trying to, with these new judges, look at how we redistribute cases, but we just haven't had the resources.
Right. And I understand that you do have that, and you have some offices around the country with similar issues, but the Albuquerque office is an outlier among outliers, given the stats, the high disability cases, the 800 people waiting 3 years before we get anything adjudicated. Do you think this severe, and let me just repeat that, this severe understaffing issues, like in Albuquerque, do you think they're acceptable?
No, I do not. Let me take a look at what's happening in Albuquerque, because that hasn't come to my direct attention.
And I really appreciate that, and I know that these are tough issues, and that they're going to take probably a range of options. But I do want to alert you that I've had very unsatisfactory in terms of not getting the answer that I desire, but getting any suggestions or any answers about what we do about this particular problem, in spite of, reaching out locally, regionally, and nationally. So given that, when do you think that you might be able to reevaluate Albuquerque staffing issues?
Well, as I've mentioned, we have just authorized hiring. It's going to take us time to recruit and to train, et cetera. So I don't want to give you a date that I can't meet. Let me talk to my staff and get back to you.
One last push in the limited remaining time, and I mean no disrespect, but no. This is critical.
I understand.
And we don't, I have not received satisfactory, timely responses. I need you to get back to me.
I will commit to that. Let me.
2 weeks, a month?
Yes. No,
2 weeks.
2 weeks.
That would be.
I may not have a complete answer for you, but at least I'll be able to get back to you and let you know what we're looking at.
I'm very grateful, and thank you for your attention to this particular problem, as it, I think, affects this problem all across the country.
Everywhere.
Thank you. And with that, Mr. Chairman, I yield back.
Thank you. Administrator, in 2011, some of the judges that were here yesterday got adverse reviews, yet they're still on the bench and no action was taken.
When you say adverse reviews, what do you mean?
They got negative focus reviews. I mean, the ranking member and I saw those judges, and we're not going to claim that we're medical experts, but it was pretty clear these 4 judges were not doing their job properly. Their incredibly high numbers were the result of their failure to do their job consistent with the norm of other judges. But they're still on the bench.
Your question?
Yeah, why are they still on the bench? Why have you not taken action against them that led to their dismissal in these 3 years?
I would need to look at their specific case to see what action is being
taken. Wait a second. You watched this hearing yesterday. You were brought here to answer our questions.
I didn't think you were going to ask personnel questions, so I didn't come prepared to answer those.
We subpoenaed 4 bad judges, compelled 3 out of the 4 to come when they refused to come in any voluntary way.
I didn't know that.
No one on your staff knew that?
I didn't ask. I mean, if they knew, I didn't see a reason to
do you not take testimony before Congress serious?
Absolutely, I do.
Then why didn't you prepare for today?
I think I am prepared.
You haven't even been able to give me one answer to a question of what authority or flexibility would allow you to do your job better. And I appreciate that you want to give me a thoughtful response, but I have a near zero thoughtful response after people leave this hearing until the next time they come back. So although I hope for this not to be the case, it doesn't appear as though you prepared particularly well. Let me
well, you gave me 2 days. You knew I was out of the country. You would not negotiate with my staff. I came in and immediately got ready for this hearing. So to suggest that I don't take it seriously, I had a death in the family, but because of the fact that you wanted this hearing today, I didn't even attend the funeral. So I'm really annoyed that you would suggest that I don't take this seriously.
Well, you didn't seem to come prepared to know about the judges we had yesterday. Are any of the people behind you able to answer that question?
No, they're not.
Couldn't you turn around and look and see?
I'm not going to have them discuss personnel issues here, Mr. Issa. I would be very happy after this meeting to stay here and answer them or to give you a private meeting, but I'm not going to discuss personnel actions here in the open forum.
I just asked why they were still on the job.
And I'm saying I don't know what the specific actions are that may or may not have been taken against these 4 judges. I would need to have a discussion.
Okay. Well, now you said that there were no quotas, no performance, and yet, and I'm asking that this be placed in the record because it cites specific quotes from Burke, Taylor, Beatty, and Cristado. These are judges who all testified there were. And they gave numbers. But let me just, and hopefully that review will help your people understand that your judges think there are performance numbers. And you said that you didn't see a correlation, but isn't it true that since the cap went down to 600, that in fact the approval rate, or the rubber stamp as we like to call it from this side of the dais, has gone down, that in fact you're approving less?
Our approval rate today is 44%.
That's your total approval rate. Your ALJs are not 44%, are they?
My understanding is that's our overall.
The ALJ's overall reversal rate, I guess technically, is 44%, you're saying today?
No, the average approval rate, the average national approval rate, once you take out dismissals, is 44%. I think you use a.
Yeah, but that's people who apply and find out they're not disabled under any definition and then abandon it, right? That's all. That's not at the point of, we're dealing with the administrative law judges. Are you saying it's 44% with administrative law judges?
No, that would be our overall rate. I'd have to see what the specific number is, but I thought it was 44%. But I may be wrong, so I would need to confirm that.
Let me ask you a question that you probably will have to give me a thoughtful answer over time. But you mentioned, and in our investigation, and in Senator Colburn's investigation, and quite frankly in 60 Minutes investigation and what was made very public, there was a practice that seemed to go like this. In that last few days or weeks before the ALJ looks at a case, the lawyers who specialize in getting approvals for their clients come in with new medical information, slip it into the file, and get it in front of the judge. So the most recent information is usually a new situation, something new to be considered. Are you aware of that?
No, I'm not.
Did you watch the 60 Minutes?
No, I did not.
Okay, so did you look at anything that Senator Colburn put out over the last 14 months?
Yes, I have.
Okay. He talks about that in his report. Do you remember that?
He did.
Okay. So one question I have for you, and it's a very straight question. Do you have the authority, if there's new information added, to seize a record, not have it go to the ALJ, and get back through the process of review again at a lower level so that it not be presented to a judge when, in fact, it's not the same package that was previously rejected?
We are in the process of
Now, ma'am, I just asked if you had the authority.
do I have the authority to?
Do you have the authority to do that? Could you have every time a lawyer at the last minute puts in additional information about his client, do you have the authority to have it go back through the review process and not go to the judge?
No.
Would you like that authority?
No.
Why not?
We have a pending regulation that will require that all evidence be submitted in a timely way, and if that moves forward, that will resolve our issue.
So what you're saying is that no new information should go into the file, even if, in fact, the patient is getting sicker during that last 3, 4, 5 months waiting for the ALJ?
I don't agree with that at all.
Well, no, I'm just asking you. You're the one that's talking about a proposed regulation.
No. My answer is no.
No what? No, you don't. No, you don't think.
I do not believe that if a person is getting sicker and new evidence is available, that it should be precluded.
So if it should be included, and you're telling me you're going to produce a regulation that says it has to be produced in a timely fashion, what you're saying is that you're still going to allow it and it's still going to go to the ALJ. Is that right? What does your regulation change?
We haven't developed that yet. We're just beginning to.
Okay, so 14 months on the job, years into this process, 60 Minutes already made it clear that there was widespread fraud leading to taxpayer losing billions.
You believe everything on 60 Minutes?
Ma'am, you're not going to gain anything from this side of the dais by telling there isn't widespread fraud that is the reason that there's a congressional hearing that you've been asked to be at. So, making the assumption that there is widespread fraud, that your ALJs have overly approved in vast amounts, and it's cost the taxpayer billions of dollars they'll never get back. I asked you a simple procedural question. That change is outside the jurisdiction of this committee, but we are a reform committee. I asked you if any kind of flexibility or changes in law would help you. You said you'd get back to me. I now asked you about one specific one, which is, did you have the authority, when new evidence comes in, to send it back to a lower administrator and not to an ALJ, have it reviewed, and then only have it go to the ALJ if it is, in fact, rejected again, that they can look at this information so that the information coming to an ALJ is exactly the information that's previously been rejected, rather than ALJs constantly looking at new information at the last minute. I asked you if, in fact, you had that authority, and you told me about a regulation that doesn't seem to, that you haven't finished.
I said, no, we didn't have the authority.
Would you like the authority?
No.
Well, this committee recently gave the District of Columbia additional authority to change the height of buildings. But a little bit like the disappointment I had when I discovered that unanimously the City Council did not want the authority to make their buildings higher under any conditions, that they were afraid of having that authority, I am hearing here today that you can't come up with one piece of authority that would help you stop the widespread fraud that this committee, Mr. Cummings, Ms. Speer, and others believe is part of it. And by the way, I want to note for the record that at least one ALJ had an allowance record of 15%. Meaning there was somebody, at least one, on the other extreme, and there are others that are low. So I am just as concerned about too low as too high, and trying to help you have the tools to do a better job. And I'm very disappointed you weren't ready here today. I suspect we will be having another hearing, and we'll invite you back, perhaps with more advanced time. Mr. Cummings, do you have closing remarks? The gentleman is recognized.
First of all, I want to express my sympathy for your loss.
Thank you.
I'm sorry we're not able to make the funeral. I want to make sure I understand what happens here. When there is Ms. Grisham, a little bit earlier, I don't know if you heard some questions I asked, but I got them from you in talking to you. you have a situation at those first two stages where you've got people who make a decision. And in many instances, the people don't have lawyers. In some instances, they, depending on where they are, who they are, they may not have doctors, medical homes, or whatever. And so they're denied quite often the benefits. Then they go to, then they basically, what's basically an appeal, I guess, to the administrative law judge. Is that correct? Is that right?
Yes.
Now, let me say that the four people that testified yesterday, I don't think there were any accusations of fraud. There were issues of whether they followed policy and their conduct. And by the way, there was testimony, if I recall correctly, that Judge Kraftner is on leave. That's my understanding.
That's correct.
All right. Now, one of the things that was said during that hearing, and I want to go to what the chairman is getting to, because I really want to make sure I understand this. One of the things that they said was, one of the judges, or maybe more, that there was a lot of times testimony or records that would come in later, and that they took that into consideration. And basically what they were saying is that the person's condition may have gotten worse, and then there was submittal of some kind of documents to show that. So how does that work? When you say that the record is supposed to be in other words, that's what I'm not trying to put words in your mouth.
No, what I was trying to convey was that we would not want to not have that information provided to the ALJ. If a person has waited over a year, that's through no fault of their own. If additional new evidence comes in that indicates that that condition has deteriorated, that may now in fact make them eligible for benefit, they are entitled to have that medical information presented. So when I said that I would not want the authority to prevent that information from being presented to the ALJ, that's what I was speaking to. They should have that information to be able to make a decision about that case.
Okay, now, if I understand the chairman's question correctly, I think he was asking about, do you want the ability to send it back to one of the first two reviewers?
No, because you can start them all over again. The case is now with the judge. Why not provide that additional documentation that will allow them to make a decision?
Yeah.
Why start them all the way back to the beginning again?
I was thinking about the man in my district, the one who had prostate cancer, who died waiting.
Right.
And a number of others. So then with regard to these folks that came in here yesterday, you said it several times you were concerned about them, right?
Yes, I am concerned because they're not making policy, they may not be making policy compliant decisions, but again, just because of their award rate, we can't make a determination just on the award. We have to do the reviews to determine if there are policy decisions that are not being policies that are not being followed. One variable is not sufficient for removal of an ALJ.
I want to make a clarification here. I want to note that the majority had a staff report yesterday, and it notes that the average lifetime benefit, including the benefit from programs linked to enrollment in a disability program, is $300,000. But this figure also includes the cost of Medicare benefits, estimated to be $109,000. While disability programs incur real costs and provide real benefits, I wanted to be clear on the cost of the benefits to the Disability Trust Fund. That is the focus of today's hearing. Ms. Colvin, the source document of the majority's estimate suggests that the present value of the disability alone is $163,000. Is that right?
I think that's more likely.
Okay. And is this consistent with your understanding?
The average benefit is about $1,500 a month, I think. And so I'd have to look at the data. And
can you get that information back to me?
Yes.
Because I tell you, I think about, I keep hearing this word, entitlement. And sometimes I think it's social insurance. I mean, basically, people pay into this.
It's an earned benefit.
I think about my father, worked 45 years, didn't miss a day, lifting drums, breathing chemicals, and paid into the system. And I think about the many black men and white men who I worked with at Bethlehem Steel as a teenager, who died before they could get a penny. And I think about folks who truly are suffering. And I'm just, I know we use that word entitlement, but the implication is that people don't pay into the system. And they do. They do. And they pay over and over and over again. So I just don't want to lose sight. And I want to make it very clear. I want us to deal with the outliers.
I do too.
I want us to make sure that everybody has a fair shot. I want to reduce the caseloads. I want to do all of that. And I want the system to work like it's supposed to work. And that's what we're about here. We're supposed to be trying to make sure that government does what government is supposed to do. There are some who believe that maybe government shouldn't exist, but it does, and it must. And so I'm just hoping that we can work with you to try to address some of these issues. And I thank you very much for being here. Thank you, Mr. Chairman.
Thank you. Madam, a couple quick things. I have a letter I'm ask unanimous consent to be placed in the record. It's from May 20, without objection, so ordered, from May 27th, inviting you to this hearing on June 10th. Were you made aware of it?
I was out of the country for 2 weeks, and I know my staff negotiated with your staff. I came back to work on the 9th, and you agreed to have the hearing on the 10th, and then it got moved to the 11th.
Well, we moved it to the 11th to accommodate your request. So were you doing official business out of the country?
No, I was on leave.
Okay, so you're on vacation. You find out you have 2 weeks before this event. We add an extra day on the request of your folks. So I'm terribly sorry for your loss, but I just want to make sure the record shows it wasn't 3 days' notice. You had 2 weeks' notice. You knew this would occur.
I was out of the country when the notice came in. I had already left to go out of the country. So
was your BlackBerry turned on?
Absolutely.
So you knew there was a hearing in 2 weeks. Is that correct?
I knew that the hearing was scheduled for the 10th, yes. Okay.
I just want to make sure that we understand that you did not have as much time to prep as you'd like because you were on vacation, and I understand that. That happens.
But I was not here in the country.
No, I understand that you had less time to prep. I just want to make sure the record indicates it was 2 weeks advance notice of the hearing, and we added an extra day.
Thank you for your consideration.
You're very welcome. I'm going to go back through just one last closing point, and I'm not going to ask it as a question, but if you care to respond to that, I will let you. This is not an adversarial relationship when somebody goes up before an ALJ. It's all one-sided. The judge is very powerful. He or she has to evaluate what is being brought. Normally, in front of the ALJ, the moving party, the disabled or presumed disabled person, is represented by a counsel who is being paid a commission on successful accomplishment most often, and they have a motivation to get the job done, to get something for their client. So you have an advocate for the client who has resources, who has medical professionals, if you will, doctors, that prepare and help the person make their case. Late in the case, after they've been turned down once or twice, and the ranking member is right, sometimes they're not represented by counsel at that time, sometimes they are. After they've been turned down twice, they come in with new information in the 11th hour. There's nobody from the government who says, hold it, we want time to cross-examine that information. We want to consider it. We want to send this patient to an independent doctor. We want to make sure that this decision is good. So this documentation comes before a judge, and sometimes a judge who approves 90-some% of the time with new information not considered by the people who also work for you, the people who have already evaluated the earlier information. Now, there's a reason not every case goes directly to the ALJs, and you know the reason, which is you have good, hard-working professionals who are trying to find out whether or not to grant or not grant disability. Those people, when last-minute information come in and it goes to the ALJ, they're denied the best information. They're denied the opportunity to make a good decision. Now, procedurally, it happens all the time in courts all over America. Last-minute information comes in, it's sent back to the lower decision. Give us an update. We'll low number it back. You won't be prejudiced other than the time it takes for this new information to be properly evaluated. You won't be prejudiced, and you'll be low numbered right back to the judge. That technique, if we give it to you, if you're not empowered to use it, and you never answer the question of are you empowered to do it, but let's assuming that you're not, if we give you the ability, that technique means your ALJs are not looking at cases that could be approved by lower individuals, as far as the rest of your staff, that would love to have had the full information, love to have made the decision, and might have said yes. That is what I was saying. Of course, I don't want people to wait in what we used to call in programming a do loop. I don't want them to, every time their condition gets worse and they submit something, to automatically wait another year. But there's no reason it couldn't go back to somebody whose job it is to make that first review. They make the first review. If they approve it, they're off to the races. If they disapprove it, they come back low-numbered to the judge. So when you go home over the next days and weeks before we likely call another hearing to this committee or another committee of Congress, I want you to really think, and I want you really to come back with reforms, flexibility changes that Congress could give you or that you haven't been using. Because I think that people on this committee on a bipartisan basis do believe that, at least in some cases, the process is failing a person by their waiting too long to get a determination, waiting too long. And part of the reason is that the process is broken and too many people are getting in front of ALJs. If you have a 50% reversal rate, that's too high. If you have a 99% reversal rate, that's too high. The difference is what we want, and I believe the injured person or disabled person needs, is they need to get the right decision as early as possible and as low a level as possible. And if there's a rejection, they have to understand that unless there's new information, that rejection will probably stand. Today, that's not the case. The numbers speak for themselves. So we didn't bring you here to just say we're mad at you. We're not mad at you. You've only been on the job 14 months, and many things have improved during those 14 months. But I'm disappointed that you weren't here with more proactive ways that we could continue doing a better job for those people who shouldn't get disabilities and for those people who should and aren't getting them or aren't getting them in a timely fashion. That's the goal of us. This is an entitlement. This is something that was earned, something that people are looking forward to as a safety net, and we're failing them. We're failing them in the time to adjudication, and in some cases, we're failing to protect the American taxpayer against lawyers who are smarter at proving a disability, or at least giving the image of a disability, than we are at detecting it. And that, on both sides of that, we want to get it right. And if the dollars spent are exactly the same, but we get it right, then Mr. Cummings and Mr. Issa and everyone else on this dais is happy. And if we get it wrong or people wait too long for this, the way they have at the VA, then we've failed people who desperately need our help. That wasn't heard by any one person here today, but hopefully I've summarized what people on the left and the right want you to do. Mr. Cummings. Thank you. At that point, we stand adjourned.